in agriculture, economic development, energy and water economics, ecological resource economics, and competition policy. He is very proud of the careers and dedication of his former graduate students from the Philippines, Thailand, and other countries. After his presentation, we will hear from two panelists. Please already come up on stage as we will be sitting. First, from Mark Waha, who leads the Asia Antitrust and Competition team of Norton Rose Fulbright, Hong Kong. Mark advises international companies on antitrust regimes in East Asia and Asian companies on global competition compliance issues, multi-jurisdictional merger filings, and international cartel investigations, particularly in Europe and Asia. For more than 20 years, he has represented clients active in a wide variety of industrial services sectors with a focus on advising Asian companies on global antitrust and competition law matters. Our second panelist is no less than Officer in Charge and Commissioner Johannes Benjamin Bernabe of the Philippine Competition Commission Authority. He served as a senior fellow at the Geneva-based International Center for Trade and Sustainable Development, where he contributed in formulating and analyzing policy reforms to the international trade system. His breadth of experience in trade regulation and economic law includes serving as a trade negotiator for the Philippines at the World Trade Organization from 1999 to 2005. During the 16th Congress, he served as the lead advisor to the Philippine Senate and House of Representatives on key economic legislation, which includes the crafting of the Philippine Competition Act. Without further ado, let me give the floor to Jim first for 20 minutes, followed by Mark and Com Joey for 10 minutes each. Jim?
Magandang hapon to you all. It's great to be here and good to see everybody. If you're falling asleep after lunch, please look at my shirt. Okay. This presentation is largely based on a paper with Maha and Sek RC, which appears in the festschrift that came out yesterday, RC's festschrift. And I'm going to add some things on sustainability. So next slide. I can only read from here.
Jim, careful at the back.
I know. Okay, so let me deal right away with the presumption that there's a conflict between competition and sustainable development. Oh, maybe I'll go over here.
Or downstairs.
This is fine, as long as I don't fall off. Okay, so I'm going to say that that conflict doesn't really exist. In fact, sustainable development is only a reminder that many generations matter, including mostly the future, and environmental amenities matter, so pollution detracts from welfare, and natural resources matter. Competition is not a goal, but a means to achieving welfare. This is enshrined in the Philippine Constitution, which says the purpose of government is to promote the common good, which means the general welfare. So welfare is the overarching goal, and we have different instruments of pursuing that. That's why we have different agencies in government. Next. So here's the popular culture version of sustainability. There's three things we're pursuing. The size of the economy, GDP. This is an old slide, but it's okay. environmental amenities and preservation of natural capital, and social indicators such as poverty. If these all are satisfied, we're in the area of intersection called sustainable development. Some people use pillars, these 3 pillars instead. Next. But the very inventor of that Venn diagram, well-known ecological economist Ed Barbier, repudiated the Venn diagram 6 months after he invented it, only it didn't disappear. He's also a drummer. Next. And the important thing about the sustainability is to recognize the economy is embedded in nature. It's all one system. We can call it the environnomy. So basically, the economy puts bad stuff in and takes good stuff out. So we have to account for that whole system. Next. Next. So there's a lot of optimal control literature, which is summarized very simply here. The goal of government as a mathematical statement is to maximize welfare over all generations, consisting of net material benefits B minus extraction costs of natural resources minus the damage costs of pollution. And that leads to 3 straightforward principles. The well-known Pigouvian principle for managing pollution, that's correcting the market so that the market efficiency is reestablished. The slightly lesser known Peirce equation for managing natural resources over time efficiently, and the principle for building total capital, not just maintaining capital, but building it through the accumulation of man-made or produced capital faster than the depletion of natural capital. Next. Illustrating this graphically, we have a production possibility curve of material consumption and environmental amenities, and those principles tell us how to get to the frontier and simultaneously move the frontier out through what's called genuine savings. Next. So as an illustration, when we come to the energy transition, green mandates and subsidies are likely to be in conflict with affordability, which I think is clarified in the Philippine Development Plan. And so they're anti-poor. Moreover, they're entirely unnecessary since utility scale solar is cheaper than coal, even if we include the damage cost of coal. I mean, especially when we do, even if we don't, and especially if we do. So government policies should facilitate a transition to affordable and clean energy, not mandate renewables before their time. I have solar panels on my house that are already outmoded. One way they can do that is by calculating the riskiness of a well-diversified portfolio of wind and solar, the problem being intermittency. So by calculating, it actually involves a covariance matrix, calculating the riskiness of the whole portfolio and helping to guide investment is one illustration. Next. Okay, turning to competition policy, there's 2 paradigms guiding competition policy. One is the so-called public interest view, which is really Pigouvian correction of market failure. It's more rigorous but naive because it leaves out transaction costs. And the private ordering approach, which sees the equilibrium, the economic equilibrium, as a mixture of markets and private governance. So a lot of transaction costs. It's more realistic, but not well developed formally. So we don't have a clean model to inform what are the consequences of operating on the economy. Next. So this is just a well-known to all the economic students, the well-known fundamental theorem showing that markets under ideal circumstances maximize welfare. Of course, those circumstances include no externalities and no non-convexities such as economies of scale. Next. So that leads to the well-known deadweight triangle, and that's often seen as the raison d'etre of competition policy. But as Danny Roderick famously said, I think I have a picture of it somewhere going like this: the deadweight loss triangles are very small compared to dynamic inefficiencies. Next. So development is all about dynamics. Even Greenwald-Stiglitz theory, which is more modern, is still static, but economic development is dynamic. All these luminaries point out that economic development has everything to do with better institutions. And we need to recognize that these drivers of productivity, specialization, innovation, and investment coordination, all involve transaction costs. And the trouble is we have limited knowledge of that system. So I'll talk about some of those next. Starting with innovation. There's good and bad of innovation. The good is that competition enhances innovation largely through the selection mechanism of entry and exit. But as Schumpeter has said, too much competition can be a bad thing, because if you lose retained earnings, then you lose the source of financing innovations for better products, lower costs, and a better business model. Next. Indeed, that is borne out empirically by Aghion and company, showing that as competition increases, innovation increases up to a point, and then at about a price-cost margin of 15%, it declines. So you don't have to worry in the Philippines, the price-cost margin is 40%, so you have a long way to go. Next. To illustrate specialization, in economics, sometimes we say specialization is learning by doing, but it goes far beyond that. In the early days, we can think of a rifle, and the different brands of rifles made their own intermediate products. But as the market got big enough, you could have separate producers of lock, stock, and barrel, at least the lock and the barrel. I'm not so sure about the stock. But those needed to be fit into the different brands. Only as the market gets even bigger can the intermediate product be tailored to the final good. Same thing happened with computer chips. Now, that takes a lot of vertical coordination. You're working with the final producer and tailoring this particular intermediate product. That takes a lot of transaction costs. So we can't be getting rid of those. Next. Next. So in fact, even as you shrink the transaction cost wedge, which is, you can think of the cost of transporting 1 ton, 1 kilometer, those costs shrink by both legal and physical infrastructure. But the transaction cost sector itself is growing because the economy is becoming much more complex through specialization. And so, reflecting on the Roderick-Fabelia debate, we need to understand that the service sector is largely facilitating specialization. In the old model, it facilitated specialization, especially within manufacturing. So if we have the new economy, I think we have to rethink a few things there. Next. Next, we have the assurance problem. Interdependent investment. So think of a farmer producing perishable vegetables and they have to be transported by a trucker. This is another classroom model. If they both invest, they both win. If they both don't invest, they both get zero. If one invests and the other doesn't, then the one that invests loses 20. So we say that's a Nash equilibrium in mixed strategies is zero. That's the assurance problem. So we need coordination. Next. Futures markets are too costly, mostly, to facilitate coordination. The Pigouvian approach of selected investment incentives requires benevolent government and all-knowing government. So that leads to non-market coordination, such as illustrated by the Keiretsu and Chaebol. Next. That brings us to Kim Sang-jo, the former chairman of the Korea Fair Trade Commission, who was very famous in Korea, known as the Chaebol sniper. And when he was here in 2018, he said, "I love Chaebols." So people thought, how can that be? Because he knew that they coordinated investment and at the same time have the danger of market power, which needs to be offset by things like the Competition Commission. Next. Just skipping to Arrow's succinct statement, it's not the presence of bargaining costs, but their bias that it's relevant. That is to say, producers can easily get together in a conspiracy to raise prices, but it's very difficult for consumers to organize a coalition to block that action. Next. I won't go into this, but this is Balesakan's famous model, pioneering model of political economy, which is essentially the coalition costs versus the benefits of the coalition, the rent-seeking benefits of special interests, and those are based on public goods theory, since that's a public good. Next. So that gives the raison d'etre of competition policy itself, because we know the equilibrium has this rent seeking. The best way to promote total welfare is by promoting consumer welfare as a countervailing power against those special interests and commercial elite. Next. We say in the chapter that the design of competition policy, which needs to be tailored to needs of a particular country, depends on understanding the nature of the competition laws, organization, and procedure, and their causes. Next. So we find that adoption of competition policy is influenced by the level of development, the international milieu, and international pressure, and what your peer countries are doing, such as ASEAN countries. Next. One result to share is the problem of reverse causation. On the one hand, higher incomes cause more adoption of competition policy. On the other hand, adoption causes more income. So how do you sort those out? So Maha and RC came up with a clever technique, econometric technique for doing that, and find that if you look at the blue lines, the adopting countries, A, grow faster than their own counterfactual A prime had they not adopted. And the non-adopting countries, the N's, also grow faster than their counterfactual, but their counterfactual is adoption. That is to say, if they had adopted, they would have grown slower, which is very interesting. And the inference there is the competition policy needs to be tailored to needs of individual countries, not just copied from, let's say, the US or Europe. Next. So moving to the concluding sections, we need to think going beyond competition as trying to get many firms and passively responding only to complaints, but going to market reviews to determine priorities. And to some extent, they're doing that already, but we're trying to study in our next paper to what extent different countries are doing that. Next. These are some of the metrics that we can, are useful. Expanding GDP to so-called green net national product, which includes pollution and natural capital depreciation. And these other measures. I should note that just because we focus on net national product as a global measure doesn't mean it's not useful to have benchmarks such as the percent renewable and keeping track of resource depletion and environmental degradation. It's just that you shouldn't have mandates on those things. Next. So beyond coordination means we kind of think of coordination as different agencies are pursuing different goals and they shouldn't step on each other's toes. But it's more than that. Rather, they should be seen as pursuing the same objective, welfare, but with different instruments. And I believe that's the underlying vision of the Philippine Economic Plan. Yeah, I think I'm out of time. I'll just stop about there. How about that?
Thank you, Jim, for keeping with the time. We'll now hear from the two panelists, Mark first, and then Joey for 10 minutes each.
Ladies and gentlemen, Jim, in his remarks, shared valuable insight on the optimal design of a competition policy for sustainable development. Can you hear me better like this? Yes. People will not need more coffee like this. And in particular, he shared some insight on how this applies in a world that is transitioning to a greener environment. I understand that his brief remarks build upon a broader body of research that he undertook jointly with our panel chair and with Secretary Balisacan. My purpose is to share my experience as a private practitioner, assisting businesses in navigating competition law constraints when implementing green or net zero strategies. For multinationals, these strategies are often set at a global or regional level. So you can immediately perceive the conflict. You just heard from the previous speaker, competition policy need to be designed at local level multinationals are thinking globally or regionally. If I offer views today, these are mine and should not be attributed to any of our clients. Before sharing these views and my experience, I would like to express my gratitude to the organizers for inviting me and to contribute to this conference, as well as my congratulations to your society for celebrating its 60th annual meeting. Now, we turn to the next slide. You will see from the examples on this slide that in recent years, there's been a significant increase in industry-wide initiatives to facilitate the transition to a greener economy. These initiatives often follow government mandates, such as, for example, a drastic change in emission standards, prompting a shift to electric vehicles in a lot of countries across the world. But they are also often following public pressure from United Nations, for example, the Net Zero Coalition, or obviously from consumer demands. While we can observe some firm-specific initiatives, in my experience, many businesses call for sector-wide coordination as a necessary requirement to achieve a prompt and effective green transition. So we've heard from Jim of the benefits arising from direct cooperation between parties active at different levels of trade, or from the chaebols that might be complementary in their businesses. But we also heard from him that the Competition Commission needs to be there to make sure that the competitive process is not affected when coordination involves competing firms. In my experience, most of the initiatives in relation to the green transition involve competing firms. So they involve the more dangerous form of cooperation we just heard about. So if we turn to the next slide, you will see that there's a lot of variety in the form of coordination. If you look to the left side, you see concepts that you will be very familiar with, but very concretely, very often industry, let's say the finance industry, gets together, says the United Nations are asking us to stop investing in dirty coal and to move as fast as possible to net zero investments. What do? Can we all agree together to stop supplying financing? But obviously, there will always be a few who will compete and make the best of these opportunities. So, this classic example is let's boycott, let's limit output together. Some may even flout ideas that go further. Shall we all agree to impose a penalty? Shall we impose 50 basis point penalty when financing coal power plants? And should that be agreed at an industry level? So, outright price coordination may also be considered. Then even lesser forms of coordination are often coming to industry participants when thinking of measuring the transition. Are we all going to use the same tools to measure our success to transition to the green economy? Can we all adopt industry codes of conduct so that we avoid greenwashing and people claiming to be doing some things that are good for the environment, whereas these are not properly measured? So you can see immediately that all of these initiatives, and without disclosing too much of our practice, this is a real trend. All of these present competition law issues because they do lead to competition restrictions. And the good news there is that there's a global alignment amongst competition law jurisdictions on what constitutes a restriction of competition. So usually when advising and when setting regional or international policies, that part of the equation is quite easy to deal with. The much more challenging part is the one that you see on the right side. What are the exceptions? What are the redeeming benefits? Can we rely on a total welfare standard? Can we look at the Philippines constitution and say, well, actually what we are doing is for the greater good. So this should trump the prohibition on cartels. This is a world of very, very wide diversity. And I've just cited on the slide a few examples of how diverse these standards are. So I'm going to explore them a little bit with you for another 4 minutes. If we can turn to the next slide. This is the starting point of the analysis in practice. And that's the easy part. You can see that the disease has spread across the world. There is global alignment on what competition restriction is and on what types of conducts are prohibited and what is not prohibited. You can see there's just a few white patches on the map, but that makes decision-making by businesses quite straightforward. Now, not always so straightforward as illustrated by the next slide. Sometimes businesses can get surprised, and this is a recent example of industry trying to jointly implement new emission standards and actually being caught by a competition authority and being sanctioned for agreeing not to go beyond the standard. So even at the start of the question, so the first question, is what we are doing restrictive of competition or not? Sometimes people are caught unaware that what they are doing actually restricts competition. But turning to the more difficult question, which is the next slide, is the redeeming benefits, the exceptions. And that is what I want to put to your conference and to this audience. Businesses are dealing with a very wide patchwork. I'm not putting on this map all of the relevant regimes, but you can see from just looking at the colors that we are looking at different regimes. First, as illustrated on this slide, a very, very significant issue is who gets to decide. Can we ourselves make the analysis and consider that what we are doing might be restrictive of competition, but actually leads to efficiencies, and therefore we just include that in our design? Or do we need to go and knock at the door of all of the red countries on the map before we can adopt a global policy? So that's a first difficult question that business needs to resolve. Another difficult question is the standard, and I will conclude on this. In a number of countries, including China, including Australia, including Singapore, you have very, very broad standards allowing businesses to rely on efficiencies, but also on global or total welfare type benefits to justify what they are doing. So in particular, in China, you can see written in the anti-monopoly law a direct reference to environmental protection and the need to properly manage national resources as a cause for justification when restricting competition. So very, very clear view from China. In the likes of Singapore or Australia, it's much fuzzier test of sort of public benefits. And that leaves business with quite a challenging position. And then, the most challenging position, and I think I need to echo what I heard from Jim earlier today, the most challenging position comes from the EU model, where we are focusing solely on economic efficiencies, and these efficiencies need to accrue to those consumers that have been harmed by the restrictive practice. So that's very, very challenging. That poses a great challenge for business when designing these policies to transition to a green economy, because very often the beneficiaries of the industry-wide initiatives are not exactly the same as the consumers that are harmed by the restrictive effect. So I should conclude here, and thank you for your attention.
Good afternoon, everyone. Can I be heard at the back? Aleli, can you hear me? Very good. Thank you all for staying on and attending this panel organized by the Philippine Competition Commission. We join everyone in congratulating the Philippine Economic Society in having its 60th anniversary today. I was trying to listen carefully to what Jim was presenting, and it made me recall why I became a lawyer. I studied economics at the UP School of Economics, but a year or two after graduating, I realized I will never be as good an economist as Jim and Maha, and therefore I decided to be a lawyer. Because in law, you read a Supreme Court decision, the first time you don't get it, read it a second time, you will get it. And if still you are having problems in understanding it, I assure you by the fifth time you read it, you will get it. Unlike economic theories, unlike the graphs that Jim was presenting, I swear, even if I look at it the whole day, I will not get it. And that's why I'm a lawyer. I'm a child of a lesser God. The PCC is a very young competition agency, and we have not really had occasion to rule as a quasi-judicial body, as an entity which makes decisions on cases involving competition, on matters relating to sustainable development. When Secretary RC was with us, we would talk about how competition law and policy interfaces with sustainable development. But because we were in a group full of lawyers, sometimes I would find that Sec RC and myself would be talking only in language that both of us could understand. And I think, notwithstanding this, there is really a great deal of importance and criticality to begin to talk about this interface, because there will be a lot of situations where we anticipate that we will face this kind of conundrum. I would hasten to say that the Commission is not precluded from considering sustainable development ideals and goals when assessing issues that are presented to it, whether in the form of cases, whether in the form of transactions which are up for review, or in regulation or legislation which is presented to us for comments. For instance, in various position papers, the most notable of which is the one which possibly our colleague, Professor Maha, Dean Maha, has also had occasion to weigh in on, and this is the reform of the energy sector, where we said that competition and sustainability are not mutually exclusive state objectives. Now, I did mention that in merger transactions, sustainable development objectives would also have relevance. And there are two cases which I can cite as having this indirect relationship with sustainable development and competition law. The first is when the acquisition of Japan Tobacco of Mighty Cigarettes was presented to us 4 years ago. And there was going to be an increased concentration in market shares. Now, any increase in concentration from a competition perspective is a red flag. But one consideration which I personally wanted to look at is, suppose there's an increase in market concentration, then what? Well, the economist said there might be a likelihood of increase in prices. And I said, so what if the prices of cigarettes increase? Is that necessarily bad? We are working so hard to reduce the consumption of tobacco products in the country. If prices increase, doesn't that go in the same direction as the whole of government approach towards reducing tobacco consumption? Now, that's not necessarily an environmental objective, but I would argue it's part of the sustainable development goals that we have all latched on to. Of course, Congresswoman Stella, who is a far better economist than I am, said that, you know, Joey, we should not take into account such extraneous factors when we are looking at competition issues. We should be competition authorities. And only if all things are equal should we weigh in on those non-competition concerns like health objectives. There was another merger which was under review by the Commission. This is the acquisition by Bayer of Monsanto, where again I reserved or made a dissent from the majority opinion which cleared the transaction. And my reservation was based on the fact that I thought that there was going to be an impact on the environment, on biodiversity that we were not looking at when examining the merger. The merger was going to be cleared because the products of Bayer and Monsanto in the Philippines did not constitute a significant market share, and therefore, to the minds of the economists, competition was not really going to be substantially lessened. But at the same time, I said, what about the increase in patent pool? What about the concentration in the hands of a few agrochemical companies globally of the power to use data when it comes to farming, when you harvest, when you plant, when you fertilize, when you harvest? What about the effects on biodiversity? The fact that we call it Roundup Ready corn would now be in the hands of a global conglomerate. What would be the impact on biodiversity in the Philippines for yellow corn, for instance? And again, of course, I was looking at sustainable development, biodiversity elements, which were not critical to a competition assessment. And maybe rightfully, I was in the dissent, and the Commission cleared that transaction. I cite these experiences because, again, I want to emphasize that while we have not ruled squarely on this issue, we anticipate that this will continue to crop up in the context of merger review or even enforcement. Enforcement simply refers to investigation of a case which might involve anti-competitive agreements or behavior. And Mark has usefully referred to the case in, I understand, the EU with respect to an agreement not to go beyond standards imposed by the Commission there, the European Commission, with regard to environmental standards. And the fine was levied in the amount of 875 million euros. What about in the case of the Philippines? What if we were to be presented a situation where there's an agreement among manufacturers not to source from suppliers who do not comply with certain environmental standards? What are we going to do? Are we going to say that it is an anti-competitive agreement because it is limiting competition to those who comply with those standards? Or do we take on board some other policy objectives. So that is the extent of where we are. But in so far as advocacy is concerned, which is an equally important aspect of our work in the Commission, we have advocated in the legislation, even as a competition agency, of the impacts of competition in its interface with the environment. For instance, when we were asked by the Senate with regard to the use of electronic or electric vehicles, I should say, we did not oppose the grant of fiscal incentives, even if it would arguably distort the market in favor of electric vehicles. And our rationale was that there has to be a consideration of broader policy objectives, including sustainable development, for us to weigh in on a pure competition issue. However, we did say that we have to propose guidelines in order to ensure that incentives are more competition consistent in a way, or lessen at least the impact on distortions in the market. Similarly, when we were asked to comment on the refined petroleum industry legislation, the PCC advocated for better implementation of the Biofuels Act by recommending a DNR-reviewed tariff on bioethanol products to increase competition. So in these various instances, we have tried to advocate for more than what competition law allows us or mandates us, but to pursue broader policy objectives. At the end of the day, in conclusion, competition cannot be analyzed in a vacuum. We are part of a whole government approach, and we have to take into account other policy objectives. I would argue that the Philippine Competition Act, in one or two provisions, which I don't have time to allude to now, certainly allow us to make carve-outs for certain industries or market players where the broader public interest demands it. I will stop here, and I hope that beyond this, we will have a more interactive discussion of this fascinating interface between competition law and policy and sustainable development. Thank you.
Thank you very much to our panelists. Thanks, Jim, for reminding us of the fundamental welfare of economics. Some of your slides took me back to your classroom. And of course, thank you to Mark and Com Joey for keeping our feet on the ground and discussing some of the practices and experiences you had with international and also here in the Philippines. Let me just have this one round of Q&A with our panelists, and then I'll call on the members of the audience. So please formulate your questions. For Jim, we've heard this morning, and I think you know that NEDA is now in the process of formulating the PDP, where metrics or indicators are identified to monitor the progress of various aspects of economic development. So you've also discussed metrics. So what advice would you give, given your experience of, given your experience and studying development economics here in the Philippines? What advice would you give, and how do we ensure, especially people in the government, people at NEDA, that these metrics would not conflict each other as we try to reach ambition natin 2040?
Yeah, so as I said, the overall metric, if we really had one, would be green NNP. And then the task is also to develop benchmarks indicating contribution to welfare. Can I also clarify that Danny Roderick said that this is the old Danny Roderick, said that the purpose of government is getting the incentives right. So that means competitive markets alone don't necessarily maximize or even promote welfare. So there's a need for correcting the market, and in respect to the green transition, the way that should be done is by putting a tax on coal according to its, we call it marginal damage cost, which is a measure of what pollution does, including to health. In fact, what's one of the biggest factors in determining the damage costs of coal is the health costs. So you can do the same thing with cigarettes if you want. So we have that actually in the book that was mentioned, Powering the Philippines, and figuring out an efficient transition. Well, we have to add to the social costs of pollution, we have to add the intermittency costs of renewables. So that's still something in process, but that's the basic idea of the green transition. In fact, if you do all these corrections, then pure economic efficiency is simply the same as welfare, enhancing welfare.
Thanks, Jim. I think some NEDA officials are still here, so I hope they can take note from what you've said. For Mark, in your experience working with other competition agency in other jurisdiction, are there any examples of environmental policies that may be in possible conflict with antitrust policies that Philippines or countries like the Philippines can learn from?
I would say certainly yes. I do not know enough about the Philippines, but certainly about other jurisdictions. Actually, you just look back at my map and you will find examples everywhere, because just by nature, most of these environmental protection rules do lead to economic impacts and very often restrictions of competition. And so that puts businesses in a quandary as to how to comply with these regulations and how to make sure that if there are any restrictions of competition, these are a direct result of government mandates and not of their own actions, as we've seen in Europe.
Thanks, Mark. For Joey, in European countries with ambitious environmental objectives, I think they are now in the process of clarifying their guidelines with regards to anti-competitive effects in contrast with environmental policies. If ever PCC is following this move, how can PCC ensure that the rules and guidelines regarding antitrust do not go in conflict with sustainability concerns? And how do we ensure that this would be according to the level of development of the country and not like just copying what other developed countries are doing?
Thank you, Maha, because that allows me to explain a little the last statement I made about provisions in the law, which would actually provide a legal basis for us to take on board sustainable development objectives. There's a section in the Philippine Competition Act, which essentially allows us to exempt certain entities from compliance with the law on public interest grounds for as long as these are not inconsistent with consumer welfare and competition issues. Now, of course, in the Commission, we have always been very careful about granting exemptions because we are a young competition agency. We don't want to give exemptions right away while we have not yet fully enforced the law. So we have been taking great pains and care in crafting the guidelines that will allow us to consider who might be exempted. And part of that discussion is indeed trying to look at what the EU has done, but mindful of the fact that the Philippines is not on the same level of development as the EU. whether we like it or not, we still rely on coal, we still rely on fossil fuels. There's a great deal of water when assessing the difference between where we are and other countries. And that is something we are very careful in taking into account. And that also feeds into the reluctance of the Competition Commission in coming up with these guidelines. I think it will be well into the term of the next set of commissioners when these guidelines are developed. But I think it cannot be avoided that these guidelines will have to take into account sustainable development objectives when we do that.
Yes, thank you. Thank you. So let me now open the floor for questions from the audience. I see Alex is raising his hands. If there are any questions, we can entertain Alex. Okay, Di.
Kung inaantok na kasi lahat eh. Anyway. It's good to see two lawyers in the middle, flanked by two economists. Frankly, disclosure, after retiring after 27 and a half years in a bank, I used to be a sustainability officer. Having said that, I can now say certain things that could get me fired because I'm already retired. Okay. Point number one, Kong Joey. I'm actually trying to wrap my head around why you're here. Because green and competition appears to be an oxymoron. In fact, I would have expected Secretary Popo and the ERC to be somewhere here. But having said that, I admire the adroitness with which you navigated your topic. But you're still facing a conundrum. And I think you put your finger on it. Because from exactly where we are, 64%, 60 to 60% of our power baseline is coal. 1% is solar, 1% is windmill. And yet we have all these advocacy groups, including members of the Bishops' Coalition for Zero Coal. Meaning, no alternative, basta stop coal lang, period. No? And if you do that, you can stop coal and then you end up with no power, which is like what Europe is going to experience because they decommission their nuclear power plants and the flow of Russian gas has stopped. So they have to suffer the consequences of a well-meaning policies. Having said that, no less than Secretary Bobby De Ocampo said in our FEF Viber group saying this, the COP27 conference now ongoing is actually a form of a greenwashing meeting with lots of hypocrisy going around. Whereas the UNDP representative this morning, Dr. Selma, said the Philippines contribute 0.03 of total emissions to the total, and yet we are being required to have a much reduction in the emission as most of the other countries, when in fact we are more victims, especially of stronger and stronger typhoons. Having said that, if you look at it from the competition policy, di ba, Joey, paano mo siya ililimit? Kasi these are very different sectors eh. Coal, hydro, you can if you can even put back the very expensive fit-in tariffs to encourage more solar and more windmills, which are very seasonal and not available during the nighttime, especially for solar. And if you want to penalize coal because of the pollution cost, as Dr. Rumaset is suggesting, you will end up with adding cost to a country which already has one of the highest energy costs in Southeast Asia. So, di ba ang isang metric lang ng Competition Commission, if it leads to lower prices, that's better. It means better competition. So how do you address that conundrum in that sense? And to Mark, the cap out statement of everybody is we will be net zero by 2050. By the time everybody is retired and it's somebody else's problem. So there's a lot of hypocrisy there that's going on, because if you look at all of these statements, nobody is saying exactly how will you achieve that net zero back from 2040, 2050, all the way here. There's no real plan to do that. All these are all statements just for the consumption of the media.
Thanks, Alex. From Joey and then Mark.
Thank you, Alex. How much time do we have? No, I'll try to be succinct. I think that competition law, in fact, acts as a moderator towards the fear or concern that you have flagged that we are rushing headlong into being green without having that kind of base that other more advanced economies are already starting from. I say that we act as a moderator because it is true that as much as possible, we would want to have an equal playing field among all energy generators, whether you be coal, solar, or other form of renewable energy. What we are not averse to is promoting and even providing incentives to these renewable energy sources or producers. How do we act as a moderator? Well, because we say that you do not necessarily have to exclude coal as a source of power for now, because it is an important source and it is a market player. And as a market player, you do not want to foreclose the market from all potential sources of energy. So that is how we reconcile it in our minds. However, that said, as I mentioned earlier, we are not averse to promoting incentives. Secondly, just as a caveat, when we look at markets in energy generation, you're right that we can actually bifurcate between traditional or conventional fuel sources, renewable energy sources, and even in terms of the geographic market where they come from. Because obviously, you have to take into account the connectivity of different island groups to the grid, whether there are undue wheeling charges that you will have to take into account because of the position of the generating facility vis-a-vis other consumers, and all of the other factors. But again, I would still say that there is no, it's not correct to say that there is no positive overlap or interface that can be explored and optimized in the context of competition law and sustainable development. Thank you.
Mark, any reaction to what Alex said?
I think the question should be addressed more to my clients. So I cannot really speak on their behalf, but what I can say is that what I observe is already immediate now challenges for providers of finance to the energy industry. Already today, large multinational providers of funding are asking themselves, am I going to receive an information request from the gentleman to my left as a result of their policies that actually lead to less funding being available to the building of power plants in the Philippines or elsewhere? So that's what I can observe already today. And so these are really challenging questions.
Thank you. Jim, you would like to add something?
Yeah, let me just say that Britain recently had the honor of having the highest electricity prices in Europe because they have green mandates and a sustainable, maybe they call it sustainability or green levy on electricity. So the highest prices, that hurts the poor. On FIT, I believe FIT actually decreases solar. Why? Because there's a permitting process. You have to get the permit. So it's entire waste of money. Utility scale solar is cheaper than coal, way cheaper than coal if you include the cost of pollution. So the question for the Philippines is, why is solar only 3% when it's so cheap? So there has to be blockades, and it has to do with government permitting, franchises. So if you want to be have a big solar farm, you need a franchise permit from the government. So these regulations are actually hurting the green transition.
Thank you. We can entertain one more question from the audience. If there's anybody. Do I see it? Okay, any last words from the panelists? We're good. Okay, please join me in thanking Mark, Joey, and Jim for this panel. Thank you also to PCC. Jim.